I'll just support my point by the very text of Article 370. Notwithstanding anything in this constitution, the provision of Article 238 shall not apply in relation to the state of Jammu and Kashmir. The power of Parliament to make laws for the said state shall be limited to those matters in the union list and the concurrent list, which in consultation with the government of the state are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the dominion of India as the matter with respect to which the dominion legislature may make laws for that state. Now pause here. It may not, what in simple language it says is that if what is mentioned in instrument of accession, somebody will have to agree that the entry mentioned in instrument of accession corresponds to any of the matters in the union list or concurrent list, and the President of India is to declare that such an entry corresponds to that list, then only the Dominion legislature will have the power to make the law. It is not straightway that we agree to the entry and they extend the law. It has to be in consultation, and the President has to almost declare it that it corresponds to the matter specified in the instrument of accession. For that consultation, the government is required. So it means it involves the President of India on the one side, and second is the government of the Jammu and Kashmir. Two are involved in this, government of the state. And then the third constitutional authority is the President, who is to declare that this matter specified corresponds to the subject of instrument of accession. Now, this is only in respect of union list and concurrent list. See the second part. Such other matters in said lists, that means union list and concurrent list, as with the concurrence of the government of the state, the President may by order specify. So here requirement is with the concurrence of the government of state, and the President is to specify in the order that matters other than instrument of accession, whether they can be extended, if so, only after obtaining concurrence of the government of the state. So this is another limitation with regard to the power of the Parliament to make law. Why is this? What is the need of this? Parliament has the plenary power. They can make any law under list 1 and apply it throughout India. Despite having acceded to the Union of India, despite being a part of Union of India, the mechanism was different only because it had subsumed the residual authority which the Maharaja had. Now this carves out the space for what we are contending here, why we are before the Lordships. What is the whole case about? We're taking Lordship's time, the 5 learned judges are hearing this matter. It's only because we believe that we had constitutional autonomy. Under the Constitution of India itself, certain autonomy was available to the state of Jammu and Kashmir, which was taken away on 5th and 6th of August. We're here contending that you cannot take away that autonomy of the state. This is all what the whole case is about. Now, I'm trying to lay down the basis. Where does this autonomy come? This autonomy comes from the instrument of accession is one. And second important thing is Article 370 itself. It doesn't give power to the institution of Parliament to make any kind of a law it wishes to make for the state, unless the state government agrees to it. And both by consultation and concurrence. For the purpose of this article, the government of the state means the person for the time being recognized by the President of Maharaja Jammu and Kashmir, acting on the advice. I'll make these submissions later. But what I'm trying to show is this important about D. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications the President may by order specify. Now, this part relates to the constitution itself. The earlier part relates to the lists. That's the power to make the law. But this clause D does not talk of the power to make law under the lists. it talks of the provisions of the Constitution of India as such. Giving power to the president, you apply the provision of Constitution side. But in order to maintain the constitutional autonomy, power is also given to the government of the state, that you can request the president, please apply this provision with this modification, with this exception, with this omission. How that is to be done, that is between the two governments. That's between the government of the state and the federal government, the central government. That's between them. That could be a political decision with which the court is not concerned. But constitutionally speaking, there is no power vested in central government or in president to make any law as they wish, as they do it in the case of other states. No consent is required from the other state. No consultation is required from any other state. No concurrence is required of any other state, except of one state, that's state of Jammu and Kashmir.